I would like to welcome you, our local audience at the Hall of the Americas of the Organization of American States, as well as our viewers and listeners throughout the Americas who are accompanying us and following the discussions live via radio, TV, and the Internet. We've put together a very interesting program on this occasion as a continuation of our monthly lecture series of the Americas. I am Irene Klinger, Director of Communications and External Relations at the Organization of American States and the coordinator of the lecture series of the Americas, and will be moderating the panel session, providing additional perspectives on the remarks we just heard from Mr. Philippe Kirsch, President of the International Criminal Court, who addressed the issue of the International Criminal Court and the enforcement of international justice. To begin, I would like to introduce our select group of panelists. You have on my right David Rifkin. He's a member of the UN Subcommission on the Promotion and Protection of Human Rights and a partner at Baker and Hofstadter. He specializes in regulatory and litigation work with a particular emphasis on constitutional and public policy issues. Before returning to the private sector, Mr. Rifkin served in a variety of legal and policy positions in the Reagan and George Bush administrations. Ms. Diane Orenlicker is Professor of International Law at American University Washington College of Law. Among many of her areas of expertise are international law, the War Crimes Tribunals, and transitional justice. She is the UN independent expert on combating impunity. On my left, Mr. Michael Mattison. He is a member of the UN International Law Commission and visiting professor at George Washington University Law School. Mr. Mattison has argued many cases before international tribunals, including the International Court of Justice, and served for more than 28 years at the U.S. Department of State, where he led efforts to create the International Criminal Tribunals for Yugoslavia and Rwanda and the UN Compensation Commission for Gulf War claims. Mr. Claire Roberts is the President of the Inter-American Commission on Human Rights of the Organization of American States and a citizen of Antigua and Barbuda. Mr. Roberts is currently dedicated to strengthening the regional human rights system and working towards the universal ratification of the regional human rights treaties. I will ask each of our panelists today to make brief introductions, and after the presentations, we will open the floor to questions and answers from the audience. We want a very interactive opportunity, and in the future, we promise our audience in the Americas that they will also be able to ask some questions. Mr. David Rifkin, you have the floor.
Thank you, Irene. President Kirsch, for his erudite remarks about why ICC is an indispensable participant in the cause of international justice. To give you a slightly different perspective, I would argue that there are two fundamental problems, at least from an American perspective, with ICC. The first problem is that ICC is, as it's organized, is profoundly antithetical to the U.S. Constitution, and therefore, irrespective of ICC's policy merits, the U.S. cannot join it. And the second, more generic problem is that ICC, however laudable its articulated goals, inherently undermines the existing international legal system and impedes the ability of law-abiding states to use force. Now, with all due respect to President Kirsch regarding his remark that there are ways of reinterpreting the Constitution, or perhaps amending the Constitution, I would respectfully submit to you that given the nature, the structure, the thrust of the American Constitution, the prospects that it can be changed to accommodate the ICC is pretty slim. The ICC is jurisdictional, the offenses, because it goes beyond extradition issues that are within the jurisdiction of American federal courts, the ability to investigate, prosecute, and punish Americans for alleged offenses taking place entirely within the United States. The United States Supreme Court has consistently held since the fairly famous Civil War case, the Constitution prohibits the vesting of such a power over U.S. citizens in any court not properly organized in accordance with the U.S. Constitution. The ICC, of course, would not be able to guarantee to American citizens the protection of the Bill of Rights. There are no juries. There are no rights to confront witnesses, at least as far as American-style jurisprudence would recognize. There is no protection, again, as our courts would recognize against hearsay evidence. There is no guarantee against double jeopardy. The suggestions that American participation in the court would not violate the Constitution because the ICC is not a court of the United States is, in my opinion, is not particularly compelling. It is precisely because ICC is not a court of the United States who cannot participate in it. And likewise, unavailing is the argument that U.S. participation would be like extradition because the U.S. ICC's jurisdiction is far greater than the crimes which the U.S. can constitutionally extradite, which have to be crimes that take place not on U.S. soil. Now, since the U.S. cannot constitutionally participate on ICC, the rest of my brief remarks would be in the nature of a friendly policy rejoinder from an interested third party. Now, I would submit to you that the most fundamental aspect of the international system, dating to the 1648 Treaty of Westphalia, is state sovereignty. It's not a dirty word. In today's world, of course, sovereignty is an indispensable prerequisite for democracy. Without sovereignty, democracy cannot exist. All international law norms today restrict this sovereignty, like norms against genocide. These norms have traditionally been enforced on a state-by-state basis. The ICC would breach this sovereignty in completely new and unique ways. ICC officials in The Hague, no matter how well-intentioned, would be empowered to second-guess the decisions of duly constituted democratic governments. Cases before ICC would be initiated not by state governments, but by a permanent independent prosecutor. The ICC would interpret international law and enforce this interpretation against individual citizens of sovereign states. I certainly would not suggest that ICC officials would act from improper motives. The very nature of any institution is to perpetuate itself. Now, while most people think about ICC as the venue to prosecute horrible war crimes and criminals, and I understand the problem of a culture of impunity, ICC can prosecute and will prosecute, I believe, a much wider variety of crimes, including things like severe damage to the natural environment. Now, who among you believes that Brazil, for example, and Belgium share the same view of what constitutes severe damage to the natural environment? Would agricultural practices in countries with rainforest resources be scrutinized by European nations that have long exhausted their own resources? Would a country be prevented from constructing a dam that would provide electricity to its impoverished citizens? These are uniquely national decisions that must be made by sovereign states. The notion that an international judicial body could end up monitoring and disposing of such decisions should be troubling to at least some of us. Now, ICC proponents sometimes minimize this aspect of its power by bringing up the principle of complementarity that President Kirsch has extensively remarked upon, that essentially limits the court jurisdiction to offenses where the states are unable and unwilling to pursue them. But we can all agree that it's ICC itself that determines in any given case where the state has proven to be unable and unwilling to investigate or prosecute, making this protection totally discretionary. Now, these philosophical misgivings, which you might surmise I have about ICC, would not compel me, most Americans of this administration, to take a particularly strong stance if ICC was content to limit its reach to those who have agreed to join it. Unfortunately, ladies and gentlemen, that is not the case. Indeed, in a somewhat unprecedented fit of some would call judicial imperialism, some would call it judicial power, ICC asserts power to subject to extradition and trial jurisdiction nationals of non-ratifying states that their actions impact states that seek prosecution in ICC. Never before in modern history has a state, group of states, or international organization adopted a treaty and then sought to impose it on other states that did not consent. The last time, frankly, that was tried was in the 19th century by the European powers operating in a somewhat discredited theories of, shall I say, imperialism, who imposed unequal treaties in China and Ottoman Port. That power is not consistent with principle of territorial jurisdiction and cannot be derived from principle of universal jurisdiction. Now, the last thing I would say is many of you may have little sympathy for nations like the United States that refuse to join in such palpably noble effort as enforcing international justice. But each of us should think long and hard about whether extending the jurisdiction of an international body over states that refuse to consent to to a given institution is consistent with good international government. I'm not going to parade over horribles for you, but I would just mention one example, Darfur. The current tensions of ICC and its jurisdiction and its assertion of jurisdiction over non-member states have greatly complicated and needlessly, in my opinion, complicated the search about how you bring to justice the perpetrators of genocide there. Thank you very much.
Thank you, David. Diane, you have the floor.
Thank you. First, it's a pleasure and an honor to participate in this very distinguished program. And it's a special pleasure for me to be here because in my work in human rights in general, and most particularly in my work as the United Nations independent expert on combating impunity, I have had many occasions to appreciate the leadership that the Inter-American Commission on Human Rights, as well as the Court, have provided for the rest of the world in combating impunity. I've had the pleasure of disagreeing with David Rifkin many times, and I could spend all of my time refuting his remarks, and in fact I would go over time. So I don't want to let some of the things he said go unremarked upon, so I will briefly note my disagreement with several points, and then I'd like to turn to a few more positive aspects of the track record of the ICC. First of all, it is simply not true that the ICC asserts jurisdiction over non-consenting states. It only has jurisdiction apart from situations where the Security Council refers a situation to the court over situations where a state is a party to the court where crimes occurred or whose nationals allegedly committed crimes, and even then the court only has jurisdiction when no state has undertaken an independent investigation of the crime. It is also somewhat troubling to hear it asserted that the United States would violate its own constitution were it to surrender someone as a treaty party to a court with numerous human rights standards of due process at a time when unfortunately, our own government is claiming the right to resort to, quote, extraordinary rendition to surrender people from all over the world to countries where there are no due process protections. But I don't want to spend all of my time disagreeing with David. What I would like to do is say that we are now at a unique point in the debate about the International Criminal Court. There's now a track record, and the court has been operating for 3 years. It has, in that time, repeatedly proved wrong, quite happily, those who've been most skeptical about how it would operate. Far from overreaching and asserting jurisdiction over American nationals, the prosecutor summarily dismissed the complaints that did come in against Americans and Israelis. It was also predicted that the court would overreach in prosecuting Israeli citizens. The prosecutor has been anything but a rogue prosecutor. He's been extremely cautious. Similarly, the judges do not come, as was predicted, from rogue states, but in fact come overwhelmingly from our democratic allies, and has operated with incredible judicious caution. There are things going on in the court that don't make the headlines, but I think people who are familiar with the court would be very proud to know. The court actively engages and has a policy of actively engaging in with governments, including governments that refer cases to the court, to try to encourage them to strengthen their own national system. The prosecutor recognizes that even in situations where it's appropriate for the court to respond to requests for it to exercise jurisdiction, it can only prosecute a handful of the most senior perpetrators. And so the court has recognized quite explicitly that it will not succeed in its mission unless it partners with national governments and national civil society to empower them to prosecute those who commit atrocities, but will necessarily escape the reach of the court. The final point I'd like to make at this point is that one of the things I've learned in the course of my work is